No, it's showing Larsa Mears, ain't showing me. Good morning, all. Good morning to everyone. On behalf of the Chief Labor Officer and the staff of the Labor Department, I wish to welcome you to today's webinar. To those of you who would have joined us before, welcome back. My name is Gail Grant, and I am a Labor Officer attached to the Industrial Relations section of the Labor Department. With me today are my colleagues, Labor Officers Larsa Mears and Donna Bess Frederick, and they will be here to assist and answer any questions which you may have. Just a little housekeeping. Questions should be directed to the question and answer chat. It's marked Q&A to the bottom of your screen. And at the end of my presentation, there will be an interactive question and answer session. But during that, you will just raise your hand to ask any questions. So today's topic. Today, we will discuss the Employment Rights Act 2012-9, but not the whole piece of legislation. Today, we will focus on layoff, short time, and redundancy. And these are quite some popular topics at this time, given the situation while we were on lockdown and the effects of COVID has caused an increase in the amounts of layoffs, short times, and then that also led to redundancy. So we start at Section 38 of the Employment Rights Act, layoff or short time. So what is layoff? What is short time? First of all, for layoff to take place, you must be an employee. There must be a reduction in the amount of work available. And the amount of money that is paid to you is dependent on the work done. The employee is not entitled to wages if the employer cannot provide work. So in other words, an employee is willing to work, but the work has diminished to a point where there's none available for the person to come to work to do it based on the circumstances. So the person is willing to work, but due to whatever circumstance has caused no work to be available. But this is only temporarily. So it's for a specific time. Now, what is short time? For short time, you must be an employee as well. And the wages are also dependent on the work being done. But with short time, the person is still working. However, they're working for less than half of what a normal week's wages would be. Or they're working for less than 21 hours. So in layoff, just to reiterate, the person is not working at all. And in short time, the person is working, but they're working for less than half of what they would normally work for, or less than half of the time they would normally work for. So anything under 21 hours. So what would cause layoff or short time to occur? Why would there be layoff or short time? If the employment has ceased temporarily, no, in both situations, it is only a temporary situation. So temporarily, the employment has ceased. And the particular kind of work has diminished to a point where the person cannot be at work. or some situation has occurred, like for instance, when we were on lockdown. So during the lockdown, no, only certain businesses were allowed to be open. So for the most part, many persons would have been on layoff because you could not go to work. And there's always that thing with layoff and short time. The employee is willing to work, but because of whatever situation, they cannot work or the work has been substantially reduced. Another thing to note is that layoff or short time is not considered as a break to your continuous employment. So even though the person may not be at work or they may be earning substantially less, the period of continuous employment still continues. You're still an employee. And therefore, if the employer calls you and says you are to return to work while you are on layoff, or you're to come into work more days when you would have considered it to be short time, then you must. You must comply because it's not a break. So, what should an employer do when the work has decreased to the point where the employees must be placed on layoff or short time? So, due to whatever happened within the business, you can offer them on court. The country has given a directive that we're in lockdown, so you cannot offer them on court. What are you required to do? So, Section 38 of the Employment Rights Act states that before laying off an employee, this is what an employer is required to do. They must carry out the consultation and they must supply the employee a trade union if the company recognizes the trade union and the chief labor officer with a written statement of the facts. It does not say that all three are to receive the same document, but it does say that each of these three entities, the employee representative, which would be the trade union, and the chief labor officer must receive a written statement of the facts surrounding the layoff. So it's a consultation with the employees, a consultation with the trade union, and a consultation with the chief labor officer. And the written statement of the facts is sent to the employees, the trade union, and the chief labor officer. So you must comply, that is, you must comply with Section 5, Section 6, and Section 7. So the statement of the facts should include what has caused the work to be diminished. So when you submit the statement of facts, you must state what is it that has caused the work to be diminished. You must also state the number and categories of those persons who are affected or who will likely be affected. The period of the layoff or the short time. So some people say, but I can't give a period because I'm not sure how long it will last. You state a period. And if you need to increase the period, then you can. Work may pick up before and you may have to shorten the period, but you must state a period. And you must also state if it is likely that other employees will be affected. So this is the information to be sent in the statement of facts. It must be sent. This is the information the Labor Department will require. Now, subsection 7. It states that the consultation commences no later than 6 weeks before the layoff or the short time, and it must be completed in a reasonable time frame. And the consultation now, you would say what method you would use to select employees. How will you carry out the layoffs and short times? You will do it in 3 tranches. You're going to do all one time. You're going to have persons working week on, week off. That is stated. And you must also state, if it is possible, that there can be alternative employment. So your company may be part of or may have other businesses attached to it that someone who works doing a particular job could easily fit in to another one of your organizations or somewhere else within the same organization to reduce the need for either the layoff or the short time. So that's when we say alternative employment, that's what we're looking at. Now, some persons ask, so what if I'm not able to give this consultation within the 6 weeks? The law makes provisions for special circumstances. So a person runs a business. You know normally what are your peak times. You know when are your slow times. Now, if you're watching how the business is going and it does not appear as though the business is operating as it normally would, you would have expected that you would be getting more business, but your projections show that it is likely that it will not happen, then you do not wait until you have reached the point where there is no work. That's where the 6 weeks consultation comes in. Because even if you do the 6 weeks consultation and then work increases and there's no need to lay off or place persons on short time, then there's no problem. But you want to make sure that you comply with what the law says. So you look at your business, you see what's happening, and from the time you see that there may be a need to lay off staff or place them on short time, then you start the process. You start your discussions with the employees, you start your discussions with the union, you start your discussions, consultations with the chief labor officer. Now, there are provisions in the legislation for special circumstances. So what would be a special circumstance? For example, there may have been a fire or some unforeseen circumstance, or even while we were on lockdown. And during these times, because it is still COVID times, sometimes we hear people say during the COVID times, but these are still COVID times. There's still the pandemic out there. So we were working, and in March, we didn't expect that we would be going home. That was a special circumstance. But you still had to consult with the chief labor officer, and you still had to take all the steps towards compliance. And I must commend those companies which actually wrote to us and had their consultations, because even though the country was on lockdown, we were still working. So we would have been receiving hundreds and hundreds of letters, and they would need to consult with those persons. Some people would have said, but we aren't sure that we could have still returned because we were on lockdown. But the legislation says that you still have to. And let me say that the Labor Department has no authority to exempt anyone or waive anyone from the 6 weeks consultation. The law makes provisions that where you cannot give the consultation within 6 weeks, then as soon as it seems as if that is what will happen, you must start as soon as it seems that way, then you must commence your consultation. So it says, and I will read it for you. Where in any case there are special circumstances which render it not reasonably practical for the employer to comply with any of the requirements, the employer shall immediately consult with the chief labor officer and take all steps towards compliance with that requirement as are reasonably practical in the circumstances. So then you don't make contact with the chief labor officer after you have gone through the process. But where it is that a special circumstance or you cannot begin the consultation until later than 6 weeks, then the legislation makes provisions that you must immediately consult with the Chief Labor Officer. Now, an employee may make a complaint to the tribunal if an employer does not follow. So the legislation says you must follow, I will go back again, you must follow the subsection 5, subsection 6, and subsection 7. But if this is not done, an employee may make a complaint to the tribunal that the employer did not follow the process. An employee can also make a complaint to the tribunal if the reason for the layoff or the short time was not related to a reduction in work. So there are situations where persons have a matter to deal with. For whatever reason, there may be a need for disciplinary action. But the employer does not want to have to write and go through the whole disciplinary process. So they say, well, next week, you normally work 5 days, only can work 2. So from the time you send a person from working for 5 days and you send them to work to only 2 days, that's short time. But in a situation like that, has the employer followed what the law makes provisions for? No. Short time and layoff comes because there was a reduction in work. So anytime that an employee sends a person on layoff and short time and they don't follow the process, the employee may make a complaint to the tribunal. And when I say make a complaint to the tribunal, the process starts with the employee coming into the labor department, making the complaint, and then the labor officer would contact the employer and we will seek to have a conciliation to see if the matter could be settled. If the matter is not settled, then it is referred to the Employment Rights Tribunal. An employee may also make a complaint that the employer did not have the consultation or they didn't produce a statement of facts. So an employee goes to work one day and heard, oh, you're getting laid off today. Remember, they said, before you lay off the staff, you should have a consultation. If it is a special circumstance, then you still have to become compliant. You must still follow the process. The employee may also make a complaint that an alternative employment is available, but it was not offered to the affected employees. And we hear that from time to time. So let me ask you. There's a situation where a person may be working at one branch and they can go to another branch. But instead of considering that, the person is sent home for whatever reason. If there is any way within the organization that you can place the person, then you need to consider that first. So in other words, you don't lay off or place a person on short time and bring in someone else to work. Because remember, when you place somebody on layoff or short time, you have stated to the Chief Labor Officer that your work has decreased to a point where you cannot provide work. So if you cannot provide work, then you can't bring in any new staff. What we will advise and what we advise here at the Labor Department is, if you have a matter which calls for disciplinary action, then you need to put your disciplinary process in place and not use layoff or short time for disciplinary action. So the complaint must be made before the end of 3 months, and that's 3 months when the layoff starts. However, the tribunal has the right to determine that a further period could be used once it is considered reasonable. Okay. Remember, you could place your questions in the question and answer chat. So Remember, layoff, you're not working at all. Short time, you're working for less than half of your normal pay. And this is all found in Section 38 of the Employment Rights Act. Now we move on to redundancy. So what is redundancy? And why would redundancy occur? So it could be a situation where you do not want to end the contracts, so you have placed the employee on layoff or possibly short time. But the time has come now where they have been on layoff for a long time, and it seems inevitable that you will have to dismiss some employees. That's where redundancy comes in. So redundancy, based on Section 29(2) of the Employment Rights Act, and if you have a copy of the Employment Rights Act, you can turn to Section 29(2), and it says that an employer shall have the right to dismiss an employee, because the legislation does mention what is a fair dismissal. And it says the employer shall have a right to dismiss an employee if it is that the employee was redundant. But it doesn't end there. So yes, an employer has a right to dismiss an employee if the person is made redundant, but you must comply with Section 31. Okay? So redundancy is a fair dismissal. So the legislation doesn't only address unfair dismissal. So it states what is a fair dismissal. Subsection 4, subsection 5, and subsection 6 of Section 31 must be followed. So redundancy is permanent. Remember, layoff and short time, they were temporary. Redundancy is permanent. It is the end of the contract of employment. It ends the period of continuous employment. The person is dismissed. And the employer is stating that there is no work available. There is no work available, and therefore you have no choice but to end the contract. It could also be that the place or the kind of work that this particular employee was employed to do has ceased. So the work has diminished to a point where you can no longer keep them employed, or it may be a situation where the person may have exhausted the time for their national insurance contributions. So having exhausted that, then the employer is left in a situation where they have to make some decisions. So how do you move forward? Redundancy comes in. So what does the legislation say about redundancy? So an employer is in a situation, they have no choice but to end the contract because there's no work available. The person has exhausted their national insurance contributions. There's no specific time when work will pick up, just as in the situation that is occurring right now within our country. So what does the law require of the employer? Now, once it is that the work has diminished, it has ceased, and you have to make employees redundant, then once the workforce is being reduced by 10%, and remember, if your business has 2 employees and one person is being made redundant, that's 50%. If you have 10 employees and one person goes, that's 10%. So once you're going to reduce the workforce by 10%, then before any of the employees are dismissed, you must carry out the consultation. Just like we mentioned previously, you must carry out the consultation. And you must supply the employees. If the company is unionized, you must supply the trade union and the chief labor officer with a written statement. So you have the consultation and you supply a written statement to each of these entities. And remember, just like I said with layoff, the Labor Department has no authority to waive the consultation. We have no permission to waive the consultation. Now that is subsection 4, because remember, it's a fair dismissal. You have the right to dismiss, but you must comply with subsection 4. You must comply with subsection 5. So what does subsection 5 say? Subsection 5 says that the reason for the dismissal must be for redundancy. So sometimes we hear from persons and they say it may be from the employer side or the employee side about a dismissal, but the dismissal was not related to redundancy. Now, in order to be entitled or in order to satisfy the requirement for severance, then an employee is made redundant. So what some persons do is say, look, I will give this person severance and let them go. But if an employer does that, once you pay the employee severance, then you're saying that you made them redundant. Because remember, redundancy is the requirement for severance. And if you do that, then later in this presentation, I will show you how it may come back to affect you. So if the reason is for any other reason than redundancy, then you must follow the 4th schedule of the Employment Rights Act. So paying severance to an employee, making them redundant, and having them go may not necessarily solve the matter. It could work in some situations, but not in all. And I will tell you why shortly. So to comply with subsection 5, the reason must be for redundancy. So there is no work available. And you must state this upfront. You must also state the number and the categories of the employees who are expected to be affected. Because remember, they're expected to be affected because they're not dismissed yet. So how many persons are expected to go? And the period when the dismissals will take place. Now in subsection 4, it says that 10%. However, it is always good to have good discussions with all your stakeholders in order to come to how much people will go on the categories, even if it is outside of the 10%, under the 10%, then you should still have that discussion. It is not a requirement of law, but it is always good to have good discussions and to see how you will move forward. So we encourage it to have the discussion. But for redundancy, it's 10%. For layoff, there's no 10%. So once you're going to lay off a staff member, you must inform the chief labor officer and follow the steps. For redundancy, 10%. And you must state the period when the dismissal will take place. So when is it likely that these employees will be dismissed? Remember, all of this is happening 6 weeks before, okay? And subsection 6, the consultation commences no later than 6 weeks before the dismissal or the dismissal. And subsection 6 states you must provide the method of selecting the employees who are to be dismissed. This is in your discussion with the union. This is in your discussion with the chief labor officer. When you're consulting with the staff, then during your consultation, you can say, we will use whatever internal methods, or you may say last name first. So, but remember, the reason for the redundancy is because there is no work available. So when you have to publish your dismissal letter, then you just state it is redundancy. If it is any other reason, then why this person is being dismissed, then you must follow the fork schedule. Can't help but say that enough. You must also state in the consultation the agreed procedure. So how have you agreed to carry out this dismissal? This is the consultation with the Chief Labor Officer. You must state the period the dismissal will take place. You're also required to state any measures that you may take to find alternative employment. So, persons they say, but why am as an employer am I required to find alternative employment? Why as an employer I'm ending your contract and I need to mitigate the adverse effects of the dismissal? Because an employer has a duty of care, and it is what the law requires. So you may be able to find alternative employment, but finding alternative employment means that if it is that this person is going to go into the alternative employment, their conditions of employment do not change. Their years haven't changed. So if they're going over, you may have someone with a business and they do the same thing, and they may be able to take over that employment. Remember, it is just as if the employee was continuing to work. So there's no change to their conditions of employment. There's no change to that pay. And the alternative employment continues, the years or the period of continuous employment doesn't end. So the day of continuous employment will still be the first day they started to work with you. Because remember, the period of continuous employment takes into account whether you're in the same job or not. So alternative employment must equate to what work the person was doing all along, and not necessarily the name of the job, but you look at the conditions. It could be better, but no worse. And when the law says about mitigating the adverse effects of the dismissal, employers could provide counseling, because for some people it is very hard to work someplace for years only to be dismissed. Some persons offer counseling, some offer training. During the lockdown, and persons had to be made redundant, or based on the effects of the lockdown, persons had to make employees redundant. Then what we saw is that employers assisted those persons who may not have the knowledge of technology to submit their forms online. That is considered mitigating the adverse effects. So there's a situation where the forms have to be sent in digitally. You could assist persons in those things, making sure that everything is submitted on time, making sure that they get their payments on time. Remember your questions, go to the Q&A chat. So, is my letter to the Chief Labor Officer considered as consultation? I want you to think about that for a minute and tell me what you think. I want one person, just raise your hand. Nobody don't want to take a guess on it, at it? Okay, so Sandra.
I guess, good morning. I guess it would be an initial step, consulting, because when the letter goes in it with the chief labor officer, then advise the employer further.
Yes,
Hello?
so yes, you can hear me, Sandra?
Yeah, I can hear you.
So you consider that the letter is consultation?
Not in the straight word sense of it, but it would be I think it would be an initial step to you've let the labor office know what you're about, and they can then tell you if you're going about it the right way or not, or advise you then. So in that sense, I would say, yeah, the step towards consultation, I would say.
Okay, so it's the initial step towards the consultation.
Yes.
Okay. So we go back to the presentation. So thank you, Sandra. And yes, is my letter to the Chief Labor Officer considered as consultation? No, it is not. It is just the initial step. So Sandra, you had it correct. The letter in itself is not the consultation. The letter would be its written statement. So once an employee sends the letter to the Chief Labor Officer, the process starts. We go through, we discuss with you. When we receive the letter or the email, we respond, we contact the persons, and that begins the consultation. So what we would also do is encourage persons to make sure you have some contact information for us. Make sure you check your emails in case we email you. And some persons we try to reach by phone, you can't get. So make sure that when you send in your letter to the Chief Labor Officer, that you have your contact information there. The letter is the initial step in the consultation. Now, what happens when there are special circumstances? So, for example, pandemic, such as the time we're in now. Suppose it's the death of the employer. What if it is a fire? Then all of these are considered as special circumstances, and the law makes provisions for special circumstances. So where it is a special circumstances and you cannot give the 6 weeks consultation, then immediately before you terminate the staff, immediately you consult with the Chief Labor Officer. And where you see Chief Labor Officer, it is any of the labor officers. The Chief Labor Officer are any of the labor officers. So you make contact with the Chief Labor Officer and you take all steps to make sure that you are compliant. So the law makes provisions for special circumstances. And I will say again, this is about the third time, we cannot exempt persons from the consultancy. Because the law makes provisions for special circumstances, we have no authority. So some persons would have received letters from employers saying that they're writing to ask for exemption. We have no authority to exempt anyone. As soon as you are faced with a situation, you must have the consultation. Now, I mentioned earlier about if an employee is made redundant, then the reason for the dismissal must be wholly or solely be redundancy. And if it's any other reason, then you should follow the fourth schedule of the Employment Rights Act. And why is that important? Because at section 40 of the Employment Rights Act, it says where an employee or employee have been made redundant and within 6 months from the date of that redundancy, there's an increase in demand and the employer must recruit employees. What happens? What is the employer required to do? What happens? So think of a situation It may not have been really a redundancy, but you decide you can, as the employer say it is redundancy, pay the person severance, you go through the whole process for redundancy. But within 6 months, so 3 months later, work increased, and you have to recruit employees. I want to hear someone. What is the employer required to do? Raise your hand. Tanya. Yes, Tanya. Let me hear you. Tanya?
Hi,
Yeah.
you can hear me?
Yes, I can.
Right. So you would be, the employer really would be required to give first option to that employee who would have been made redundant.
That is correct. That is correct, Tanya. So, right. So, what is the employer required to do? Tanya, you are correct. The employer is required to give that person priority in recruitment. But the law says, provided all things are equal. So if you have a situation where there was a need for disciplinary action, but instead of going the route of disciplinary action, or you never had appraisals, but you just, as the employer, decided, look, I'm going to pay this person severance, I can make them redundant because I want them out of this business. And now you have to recruit employees. How are you going to say that this person did not meet the required standards when no appraisals were done? So now you find yourself in a situation where the person who you would have paid out is the same person you now have to give priority in your recruitment. Remember, questions go to the Q&A chat. Now, that employee who was made redundant can now make a complaint to the chief labor officer or sent to the tribunal that the former employer contravened their duty in section 40. So there's a need to rehire. The person, as far as you are concerned, was not up to the standard that your company works at, or they would not do well going forward. So you went ahead and you hired new staff and they were not part of the hiring process. That person can make a complaint. And the complaint must be presented to the chief labor officer within 3 months of the commencement of the new employee. So some of these people say, but the person in the employee, because I ain't paying the NAS or I ain't paying the tax or I ain't put them on staff. And they will say, as all my colleagues have said in their presentations, those are not determining factors in whether a person is an employee. Those things do not affect a person's rights, whether they are on staff, whether they're temporary, the permanent, apprentice, on probation. The beginning of employment is still the beginning of employment. Whether you pay the NAS, whether you pay taxes, those are not determining factors. So if it is that the person is made redundant and there's a need to hire staff within 6 months, then priority is given to that person. So who is a new employee? Any employee other than the employee or employees made redundant in the particular circumstances. Because remember, during the consultation, you would have stated what the circumstances are surrounding the redundancy. So therefore, it carries me back to the point where the reason for dismissal must be redundancy. If there's a need as an employer to follow the disciplinary process, then the law makes provisions that an employer has a right to dismiss if it relates to the person's ability to do their job, if it relates to their conduct, the law makes provisions that it is a fair dismissal once you follow the process required. So in summary, layoff or short time is temporary. And during the layoff or the short time, the employee is still employed. Redundancy is a dismissal of the contract of employment. So that is permanent, the contract ends. Severance is payable only if an employee is made redundant from the employer's end. I'm not speaking about when people trigger the severance, but severance is payable when an employee is made redundant. If the reason for dismissal is other than redundancy, then employers must follow the force schedule. And remember the procedures for the layoff, the short time, and the redundancy. Contact us at Labor Department, check our website. At the end of the presentation, you will see our numbers. Give us a call, and we will be willing to go through with you the procedures. Now, also what is important or what we find significant is the 6 months. So you would see it speaks about the 6 months in rehiring. But there are a lot of things that link back to the 6 months. So 6 months for the layoff or short time, that's the maximum time. 6 months equates to 26 weeks. The 6 months within which you could rehire. 6 months, and you see, the thing is, laws complement one another. To make certain complaints, you go over the 3 months or 6 months. So the laws work together. And what we do as the Labor Department is we encourage you to just follow the process. Thank you very much for joining us. And at this point, I will open the floor for any questions. Remember to ask questions, just raise your hand. So Sandra, we'll start with you. Go ahead, Sandra. Your mic is off, Sandra. You need to turn on your mic.
Okay, yeah. I was going to say, isn't there no legal way to get around having to rehire an employee who was not really a good performer, but who you'd let go before you made redundant? There's no way of getting around having to prioritize rehiring that person.
Well, there's a simple way to do it. It's quite simple, actually. So you have to make a person redundant, but the person is not what you consider the best employee. Remember, at the time of the employment, you would have settled in your statement of employment particular what is expected. So if this employee, they're not able to do the work, they're not getting the work done, then that is why it's important that you do appraisals, because you must have something documented. You must have something, you have a performance objective, and then you meet to discuss and see if the person is getting it done. If the person is unable to satisfy the requirements of the job, then there's no need for you to get around it, because in your recruitment process, you can clearly show if the employee decides to challenge it and say that we're not part of the recruitment process, you would have your appraisals there to show that the person did not satisfy the requirements of the job.
Yeah, that is true. But you know, in a lot of small businesses, sometimes they don't do appraisals.
But there must be something in place. If a person, even if you don't do appraisals, if a person isn't doing their job, then you need to write.
Right, give them a
Otherwise,
warning.
right. And remember, when you give an employee a warning, sometimes I see people have, once you accept this, then what is stated here is true. When you give an employee a warning, when they sign it, they're only signing to say that they received it. If they receive the warning and they're not in agreement with what is written, then they will write to say that they don't agree. Sometimes people come to us and they say they're not taking it. Well, not taking a warning doesn't mean it doesn't go on your file. So what we encourage from the employee side is if you receive a warning or you're not in agreement with it, then the only way for you to state that you're not in agreement with it is if you take a copy and write back. Because if you don't take a copy, then you're pretty much accepting that is what it is. So we just ask, you see, in these times, you have to have things documented. And even small businesses have to write. Okay?
Yeah, but
So,
no saying about
yeah, but with the because of how society changes, then as things change, you have to conform. So if you have a small village shop, then normally in situations like that, it's not very formal. So it is, but even in situations like that, you have to still document and write. Otherwise, you're giving the other person all the right. You have to cover yourself, right? All right, so thanks, Sandra. Tanya?
Hey, sorry, I put my question in the Q&A section, so but it hasn't been answered yet. So should I still ask it here?
Yeah, you can go ahead.
Okay. Oh, sorry, no, Layla, she did answer it, so never mind.
But you can still answer it for the benefit of everybody,
others,
if you
all
don't
right.
mind.
Right. So I was just asking if an employee was made redundant and then hired back like 3 months later, whether their start date would be when they came back or whether it had to be the original date, even though 42 days had passed.
The start date would be the new date.
New date, yeah. Thank
Remember,
you.
the person was made redundant, they were paid severance. And if you look at section 4 of the Employment Rights Act, where it speaks to the period of continuous employment, it states that speaks to the period of continuous employment. It says specifically that the period of continuous employment ends when the person is paid severance and the employment is formally ended. So it would start now, the person will have a new employment day and those years will be gone because they would have already been paid. Okay. Any other questions? Let me see the chat box. So the question is, what happens where the alternative employment is at a lower level than what the employee currently carries? For instance, a manager moving to a supervisor. So when we spoke about alternative employment, we spoke about it being lateral. So if you're going to offer alternative employment, it should be on the same level. There should be no disruption to them. So the benefit, alternative employment usually equates to something similar. Now, if an employee is willing to accept that, if it is a substantial change, then as an employer, you can still have to make them redundant. If any change to a person's contract is significant, because remember, redundancy means that job ain't available. So if the job ain't available and they now have to take something which is less, then you have to formally end that contract. But it will call for some discussion. And this is what we like to encourage, discussion. So you will have to discuss it and see how beneficial it is for a person to go. The person, if it is a significant change to the contract of employment, it will still entitle them to severance, and then they start over in the new position. And to anonymous attendee, at the end of our presentation, you will see our numbers. And what we encourage persons to do as well is, because we're only so much of us to cover the whole island. There's only very few of us, it's less than 10. So what we encourage persons to do is to send their queries by email as well. You can, at the end of the presentation, you'll see the email addresses. I'll have mine at the end. And if you call and you don't get through, feel free to send us an email and we will respond. I see a question here by Tracy Brathwaite. So.
Hi, morning, Gail.
Good morning, Tracy.
I'm asking, is it legal to ask employees to sign an agreement to pay severance in 6 months apart without going through NAS? And if the employee does not sign, what is the right thing to do? Bearing in mind that the company does not have all the money at this time.
Okay, so what we said is that, what I said just now is discussion. So I will note the points you made. So the company is willing to pay the severance?
Yes.
Right. And they're willing to pay it within 6 months?
Yes.
No. Now, one of the things the person will have to do is to speak to NAS, because the payment of severance is under the purview of the National Insurance Department. And the legislation says that it is to be paid in 2 months. However, if it cannot be paid in 2 months, then with the permission of the Director of National Insurance, it could be for a longer period. So the Director of National Insurance should be involved. But let's be realistic as well. You're faced with a situation where the employer willing to pay, and we all know if you have to wait on national insurance, it can take a long time. So both parties could approach the NAS and state they're willing to pay it, come up with an agreement and stick to it. Then I'm sure it will not be a problem. But national insurance would have to be involved once it goes past that. Once it goes past the 2 months, then you will have to seek permission of the Director of National Insurance.
So what if you originally had promised the staff to pay in 2 months and then you recant your decision? Can you do that? And you're now forcing employees to sign a document.
But as you know, and I know, there can't be any forcing anything with employment. Is a mutual agreement, because it is a contract. And remember, no one party to a contract is over the other, it's mutual. Okay. So once it is a contract, no one person can unilaterally change the terms and conditions. It must be an agreement. In any contract, employment is a contract. So there's no one party may have more power and another party may be more vulnerable. But when it relates to the actual employment, then the two parties where no one party seeks to disadvantage the other. Okay. So it will call for discussion, and probably in the consultation, the two parties could come up with some type of agreement to approach the national insurance. Okay. Once the two parties agree.
Noted.
Right. Sheldine.
Good morning, everybody. I just have 2 questions. One, I know that severance is only paid after the person has been employed for 2 years. However, in this economic situation as a result of COVID-19, if you're in a business where the decline is so drastic and you need to make positions redundant, how will you handle that? Would it only be accrued holiday, etc. that's paid?
Just let me verify. So you want to make employees redundant, but they have not completed 2 years?
Correct.
Right. So the law does not say that you cannot make a person redundant who has not worked 2 years. What the law says is that a person is not entitled to severance if they haven't been employed. The period of continuous employment is not 2 years. So you are to follow the process, because if you do not follow the process, then the employee gets the right to make a claim for unfair dismissal.
Mhm.
So if a person is employed for only a year, they're covered under the Employment Rights Act. If you look at the fact that the person does not qualify for severance and you don't follow the process, then that employee can make a claim for unfair dismissal. And the minimum compensation equates to what severance would have been. So even though that person didn't work for 2 years, the compensation to be paid would be the 5 weeks pay, which would be the same as if they had completed the 2 years.
Okay.
Answer
And
your
then
question?
yes, we did. We've followed the process generally. I just want to be sure that we were on the right track.
Right. So a person does not have to satisfy the requirements for severance in order to be made redundant. Remember, the redundancy comes because there's no work. So at whatever point that happens, it happens.
Okay.
It's based solely on that fact. Okay.
And then will the PowerPoint presentation that you just completed, will that be sent to persons who are on the call, on the Zoom call?
No, it will not be sent, but it's on our YouTube channel for some time. I don't know how, but you can go to visit our YouTube channel, and it's Ministry of Labor. I think it's Ministry of Labor Barbados. And you can look back at this presentation, and you can also view the ones on disciplinary action, holiday with pay, sexual harassment. We have quite a few videos there of our previous webinars.
Okay, thank you.
Oh, you're welcome. Tanya, you have another question?
Yes, please. If you have given consultation, so you are making positions redundant, you gave consultation with all the relevant information, you didn't provide the statement of facts at that time, but you included the information in the person's termination letter, will that still be grounds for a claim for unfair dismissal?
Was a consultation, did you have a consultation with the staff at all?
Yes, so you had the consultation and you gave them the information that was required, but you didn't do that statement of facts at that time. You included the information in the termination letter.
So in the termination letter, you stated that the consultation took place at so-and-so date.
Yeah, so it had when consultation was given, it had when notice was officially given, and then it had the details about the severance and the severance payment.
Okay, well, the dismissal letter would show that you followed, but what we would encourage you to do is at every step, you should distribute your documentation. So there's documentation for every step, and not just wait until the end to give the documentation that all of it occurred.
Okay.
Because you would have followed the process, but you just give the documentation at every stage.
Okay.
Okay. Any other questions? So we have Pamela. Go ahead, Pamela. Pamela, you have to turn on your mic.
I
Your
just
mic is
realized
on.
it's on you now.
Mhm.
Can I
Go
ask a
ahead.
question outside of what we are being discussed here this morning?
Okay, go ahead. Once
Okay.
I can answer.
Okay. I have a situation here. where an employee was on probably about 6 months or so sick leave, came back into work September this year. But they're asking this for vacation later in December. The question is, will they be still entitled to vacation?
Okay, so just let me recap. The person was on 6 months sick leave.
About that, yes.
Right. The person returned to work in September.
Yes, this year.
And they're asking for a vacation in December. Now, in order to answer your question, I have to ask some questions.
No
You don't
problem.
have to answer these questions, but these are the questions. These answers to these questions will determine whether the person eligible for vacation or not.
Okay.
So the first thing is, what's the person's anniversary date? Because remember, a person becomes entitled to vacation not based on a calendar year, but on their anniversary. So what month did they start to work?
Well, the interest in this person that at the company for 33 years. So I don't even know the anniversary date.
But they must have a record of this start date.
Yeah, they have, but I don't have that on hand at the moment.
Right, but as I said, these are the questions. You don't have to answer specifically.
Okay.
So you look at the person's anniversary. No, because the person would have been there for 31 years, then with them taking vacation, I'm sure the company allows them to take vacation whenever time of the year that they want to.
Yeah.
But because that they were out for the 6 months, the first thing the company could do, and this is just broad, the company could go ahead and give them vacation just based on the fact that they were there for 31 years or that they can get vacation anytime. The company can make that decision. That's number one. To determine if they're eligible now for the vacation is a different question.
Okay.
Because an employer could do more than the law. They can't do less than the law. So you can grant a person vacation even though they're not eligible, because people get vacation in 9 months and the law says a year.
Yeah.
So you can give vacation even if it is not due, you can give vacation. But it is a requirement under the law that if a person is monthly paid, then during the year of employment, so say for example, the person anniversary date is March. Then between March 1 year to the next, then that person should work a total of 208 days. If the person is weekly paid, they should work a total of 150 days. So that's why you need to see what date the person starts, so you can see what their year of employment is. And see. Now, depending on when their anniversary is, they may or may not require the person is monthly paid or weekly?
Monthly.
Right. So it depends on what part of that 6 months the anniversary falls. The person may not have gotten the 208 days. But in the end, the decision is up to management. A person may not be eligible for a vacation, but that does not stop them from still getting some type of vacation, because once a person works for 3 months, or if a person terminates the contract, or whether the employer terminates the contract, you're given your average pay. So as the employer, you could go above. So in the end, the final decision whether the vacation will be given or not is up to the company.
It's up to the company.
Right,
but
whether
you're
it is granted. But
right.
the eligibility is based on the amount of days that the person actually worked.
Okay, so you're saying this 208 days have to be completed before vacation can be granted?
No, I'm not saying that, because remember he said some people get vacation in 9 months.
Okay.
And the vacation legally is not due until you complete a year.
Okay, but the important thing is the person anniversary date. When is their anniversary date? And then the sick leave was broken, if it was broken before or after, and then how they would calculate the days within the time frame. from September to December. That's how the company can go about it.
They can do it that way. But you can't just forget the period before the person went on sick leave. You must look before the person went on sick leave, were they eligible for vacation? Say, for example, the person went off in March, but their anniversary was February. So they were due vacation at February, but they went on sick leave then, so they didn't get the vacation. Then in a situation like that, the person is due vacation.
Yeah, okay.
And I will say as well that you must keep track of people's anniversaries, because once more than 6 months pass, when the vacation is due, then there must be a signed agreement between the employer and the employee stating when the vacation will be given.
Okay.
But as it relates to the vacation pay, you can grant the vacation. It's up to you to decide how you would give the vacation, what payments you would give for the vacation, but the person may not be entitled to pay 3 weeks vacation.
Right. Gail, you probably laugh at this. I'm saying that this information is so important and critical. My thing is, do you guys come into a company and share to companies? Can we say you do that?
Yes, we go to companies. We go into companies and we inspect records, which will be on our part. And then we would advise accordingly. And we go into companies at the request of the employers. And we speak to staff, or we go sometimes and we meet with the accounts departments or the persons responsible for the calculation of vacation pay. And we go through with them and we offer the guidance necessary. But in the labor department, just for a little knowledge, every officer has an area. So what we do is we go and we do inspections. So every time the labor department visits your company, it is not that somebody called, it is that we have areas that we can visit, and we are not required by law to say that we are coming.
But well, you could tell me who because
you could chat, you could send in the Q&A chat if you need to find out anything specific. Put in the Q&A chat, and one of the officers will answer you if you want to find out who's the officer for your area.
Who's the officer for university.
All right.
Open campus, yeah.
In the Q&A chat, and one of the officers will answer and tell you who the officer is for the Black Rock area. The person for Black Rock normally goes with St. James. So they will tell you.
All right, thank you so much.
Okay, all right, bye-bye.
Okay.
And Tanya again.
Hi, yes, please. If a job that was once required to work for 5 days a week is now needed just for 3 days, and the employee doesn't agree with making that change to their contract, would that be grounds to make the role redundant?
Okay. So the person was required to work 5 days.
Yeah.
And now they work 3?
No, it hasn't been changed in lateral leave, but the demand is for 3 days. So that's what the employer wants to do going forward.
So you have a discussion with the employee, but in a situation like this, remember we spoke about significant change. So even though the change from 5 days to 3 is a reduction, when we look at significant changes, we look at how these changes affect a person's entitlement. So 3 days, a person is still entitled to vacation. At 3 days, a person is not on short time. So I don't know how it is that an employee could refuse to agree.
Well, I guess they're kind of their understanding might be that they can refuse because it's a question being asked as opposed to a statement. So we're saying, the demand has decreased, we don't have any bookings, and we would like to make this change. How do you feel about that? That allows a person to say yes or no versus, saying this has happened and we are making the change.
Okay, but yes, the person needs to agree. But what is the situation? Let's be realistic. If the person doesn't agree, because right now with 3 days, they still can get vacation. They're still eligible for vacation. They're earning more than half of their pay, so they can claim short time. So the only other option is if the person is not willing to accept, what does the employer do? Because is that considered a fundamental change? It is important that the two parties sit down and discuss, because if it is that your employer requires you to be at work for 3 days, it is a change, but it is not significant enough to disadvantage you from any of your entitlements. What the employer needs to say is it is for a specific time.
Okay.
So it cannot be a permanent change, or it should not be a permanent change. Remember, as I said, it's a contract and both parties would need to agree. So some discussion must be had about there must be some discussion about
time
if
frame.
the person does not accept, or that it is only for a specific time, to give them the assurance that you are not seeking to change their contract permanently. It is solely based on the fact that there's no work available.
Okay, so if there is sorry, go ahead.
If it goes down to 2 days now, then you're looking at a situation where you're getting less money. You're going to wait on national insurance to give you the difference in your money. So if an employer is willing to give 3 days, what we encourage you to do is to give a specific time.
Give a time. Okay.
And I will say as well that employees can tell if the business has increased.
Yeah.
So you stick to your agreement. If it is that the work increased, then you don't still keep the person on the 3 days, but you sit with them and you give them the assurance that this is only for temporary. This is temporarily. Remember, we keep getting questions all the time about persons saying this is what it is. If it is a significant change, like cutting 50% to your salary and stuff like that, then that would be a significant change. But from 5 days to 3, not necessarily.
Okay.
But you have to discuss it.
Significant changes, though.
Fundamental change. Yeah.
Would warrant redundancy.
Yes.
And regardless of, so for example, if you went down to 2 days and that's a significant change.
Yes, because remember, 2 days now means that you're not earning any vacation, because if you only work in 2 days, you home 5. You have to work at least 3 days to be eligible for vacation.
Okay.
So you're not earning vacation. You got to go on short time. National insurance got to pay you. So these are significant changes. You could only be on short time for a specific time, because remember, the national insurance to be paid then would reduce your earning capacity. Remember, once you go into short time, your earning capacity it has been significantly reduced.
Yeah, less than half.
Right. So.
And with making that position redundant, even though the role is still needed, but for less days, you still can't rehire in that same role for 6 months.
No, because if it is that there's no work available and you have to reduce my days, then how could you hire somebody else?
Work is still available. It's just significantly less work than what was before.
No, but then you could spread out the work. Instead of bringing somebody else, you could spread out the work over 5 days then.
All right, I got to process that one.
I know what I mean, because in situations like certain employees, you're looking probably like at the amount of houses available, so there's work available. But you may have to have less persons. You may have to, with whatever persons you have, let them go to more than one.
Oh, okay.
Place. Right. So if work increases and you can only provide work 3 days at one place, they might want to work 2 days someplace else to make up for the 5.
Okay.
Instead of bringing in somebody to work the 2 days.
Thanks.
Right. So discussion.
Yeah.
Right. Any other questions? So Sandra, one of the officers will answer you as it relates to the person for your area. And Christchurch is divided, it's not one officer. Christchurch has two officers because Christchurch has quite a few businesses. So there are two officers which are assigned to Christchurch, one seaside and one landside. I should not have said that. That is our internal interpretation of it. Okay. So I have a question here. It's not directly related to redundancy, but I will seek to answer it. There are two questions. So a question was asked why the vacation wasn't taken. The person said for personal reasons, it was not deferred by the company. So I will say that when a person applies for vacation, they're just requesting that vacation is taken. The employer will approve the vacation. Now, when an employer says that they're not going to take vacation for personal reasons and that it was not deferred by the company must make sure that the vacation is given to the employer. And I'm not saying just give them the money without the time, but the money and time goes together. So no employee can determine when they go on vacation. You can make your request, you can ask to go on vacation, but the employer determines when you go on vacation. And once the employer gives you the 14 days notice and says to you, you are on vacation, then you have to go on vacation. You cannot show up at work and say you're not going on vacation. So if it is that your vacation was approved and for whatever reason you cannot take it at that time, the same way we ask employers to discuss as an employee, you would have to discuss it with your employer and come up with an agreement about what date it will be given, because there are legal implications for the employer who does not give the vacation that is required to be given. So it is okay for employees to say they don't want the vacation or give me the time and give me the money, but don't give me the time. But the employer must follow what the law says. The time and the money goes together, and no employee can determine when that they want vacation pay, but they don't want the time, or they don't want to go on vacation. It is the employer's responsibility to make sure if persons don't apply for vacation, roster them, but they must be given the 2 weeks. I hope that answers your question. I need a little verification on the question about short days. I need a little verification. So the contract, my contract is for monthly payments. So the person is employed to be given a monthly contract, and they have been paid 2 weeks or weekly for the last few years. Does this void my contract? No, it doesn't void your contract, but it doesn't necessarily change your monthly pay. It could be that a person is employed for, let's say, $2,000 a month, but the employer decides to pay that weekly. It is not how regular you get the pay, but the actual rate of pay, and to make sure that the rate is, the amount given is not less than what the rate would equate to. I hope that answered your question. Any other questions, live questions? I would like to thank you for joining us today, and I hope that the information is helpful. What we want my feedback on hearing from you about what it is you would like us to talk about next. You can send your suggestions for different topics you may like to hear. Any employers that want us to come in to speak with your accounts department to make sure they are they correct, or if you want us to speak to the employees, or just to have, sometimes we go in and we just have an open forum and we discuss. Sometimes we meet with the boards of management. I would just say this as well as it relates. I want to say this with the vacation. You have to look at what a person is entitled to vacation at the period of time. So what happened in the previous year does not necessarily affect the next year. So if there are no further questions, thanks once again. It was indeed a pleasure for you to join us today, and we'll see you at the next webinar. Thank you. The question and answer chat box will remain open for a bit after the presentation, just to complete the questions that are already there. So do enjoy your weekend. Bye.
We can dream because there is where it all begins, with a step, knowing we can do it. See the light, it's time to realize our potential to grow, to be whatever we dream. Focus on our goals, to be the winners with science and technology. Together we can go far. Pride and industry, that's our motto. So getting qualified, we can go far. We've got skills, we can compete, develop, train, innovate. Come on, be unique.